Welcome to the Mulcahy Law Firm podcast. For over 25 years, Mulcahy Law Firm has helped plan communities and condominium associations throughout the state of Arizona. Please go to iTunes or your favorite podcasting platform and leave us a rating and a review. Thank you for listening. Here's Beth Mulcahy.
Hi, everybody. Welcome this morning to our 2024 virtual HOA Condo Academy, our July edition. Welcome. Thank you so much for being here today. I hope you are surviving the heat this summer, or maybe you're somewhere nice and cool, getting away from the Arizona heat. Today, our class is going to be really focused on summer planning and what you can do over the summer to kind of get ahead for your associations. So our main topic today is going to be amending CC&Rs and implementing rental restrictions. And then we're going to flip over and talk a little bit about your 2025 budget planning. So as part of the class, we're going to be learning our 5-step plan, which we have, developed over the past 25 plus years to help associations successfully amend their CC&Rs. We'll also provide an overview of how to provide an HOA or condo budget for your association for 2025. We'll also give you the question and answer at the end of the class today, which is probably one of our most popular features. We answer every question that's submitted to us each class that we teach. So good morning, everybody, and welcome to class number 7 of our firm's 2024 virtual HOA Academy. We have a partnership with the following cities to teach these classes. So I'd like to give a special shout out to them and a thank you to them for having the vision to have these free classes for their residents where they can learn about a topic and then ask questions and have them answered in real time. So thank you, everybody, for being here today. Just a little introduction for those of you who might be joining us for the first time. My name is Beth Mulcahy, and I am the managing partner and senior attorney for the Mulcahy Law Firm in Phoenix, Arizona. I have enjoyed representing as their legal counsel, HOAs and condominiums in Arizona as their legal counsel for over 27 years. My firm currently represents over 1,000 planned communities and condominium associations throughout the state of Arizona. I also currently serve on my HOA board and have for many years. The main topic, as I said earlier for today, that we're going to be talking about is going to be amending CC&Rs, and then we're going to be talking a little bit about budget preparation for 2025. As always, feel free to submit your question in the Q&A box on Zoom and in the comment section on Facebook if you're joining us on Facebook Live. All questions will be answered at the end of the class, likely right around 12 o'clock or 12:15. And friendly reminder, today's session is limited to one question per attendee, and we appreciate you understanding that. We get a lot of different questions. It looks like we already have 142 people that are with us on our Zoom, and many more of you are joining us on Facebook Live today. Okay, before we get started, I always like to know who is my audience here today. So I'd like to start off by doing a little poll so I can find out who's here so I can best tailor our presentation today. So if you're joining us on Zoom, you're going to be seeing a poll question that's up. But if you're joining us on Facebook Live, just let us know which city you are residing in, and then also let us know what your current role is. As the results start to come in, or maybe they already are coming in, I will talk briefly about the recent legislative session and the new laws in Arizona. So briefly, let's do a quick little 2024 legislative update. There were a number of bills introduced in the 2024 legislature this year. And what I've tried to do over the past few weeks is simplify as much as possible what you need to know about these laws, because to some degree, they are kind of complex. I would be lying to you if I didn't tell you that I've spent the last couple of months thinking about what is the best way for me to summarize these so that it's really easy for everybody who's listening in on these classes to understand the laws and follow the new laws. The effective date, or the date that these laws all become, the law in Arizona, is September 14th, 2024. So that means that all the laws are going to take effect on that date. So we have a couple more months to kind of get up to speed and to determine how we can best all comply with the laws. Okay. So what I try to do is just do a breakdown of, the 9 or 10 different laws that I think you need to be aware of. I know that sounds like a lot to bite off, but Best way to eat an elephant is one bite at a time. So very quickly, we're just going to do a very quick overview as we get closer to September 14th, when these laws become effective. We will be doing more talking on a more extensive basis. We'll probably have one class that's partially dedicated to just analyzing these laws and answering your questions too. So here are the most important things you need to know about the 2024 new legislation. So first thing, there was a bill this year on transfer fees or capital contribution fees. And basically, the main gist of it is that planned communities and condominiums can't charge transfer fees or capital contribution fees in these circumstances. And very limited circumstances, most of our clients were already not doing this. So you can't charge transfer fees or capital contribution fees when there's a nominal consideration paid. So like an example would be like $1 to transfer the deed from, a familial relationship. So from the husband to the wife, or from parents to their children, or if it's through business entities from one LLC to another LLC because they're related in some way. So for the first, just on transfer fees is when there's a nominal consideration and there's a familial relationship or some sort of a business entity relationship, and that's why there's going to be a transfer of title from A to B, we cannot charge that transfer fee or capital contribution fee. I don't think that's going to have a big impact on any of the associations in Arizona. Next, a new law, the second one, talks about condominium improvements. So this only applies to condominiums. And basically what it says, if an owner wants to make an improvement, probably the most common one that comes to mind would be an owner wants to change from carpeting to hardwood floors. In the condo association, the board cannot prohibit it as long as the owner purchases, installs, and pays for anything necessary to eliminate or minimize the disturbance to the neighbors. So probably how this came about is, there are some condo associations that don't allow hardwood flooring. And, basically what the legislature is saying, okay, you can't do that anymore as long as the, individual owner who wants to make the alterations does whatever is necessary to purchase, install, and pay for anything that's necessary to eliminate the disturbance. So, the type of things that I can see coming out of this would be the association approves the change to the hardwood floors, but the owner has to do a special sound barrier. There's a special corking that you can do, and all of the companies that install hardwood floors would understand and know what that means. Or maybe that you make them have area rugs. I mean, those would just be some examples. Again, this law probably doesn't have far-reaching implications for condominiums, but I'm mentioning it so that you're aware of it. The next law is kind of confusing, and I want to just simplify it as best as I can. It deals with collecting assessments from owners in an association. And what we've seen over the years is a lot of regulation of associations on collection of delinquent assessments. So taking away the associations, kind of their legal remedies, watering them down, et cetera, to give owners more time to pay back their assessments. And this year is kind of no different. And so kind of this law had probably 7 or 8 parts of it. But the basic thing on it is, okay, an association is trying to collect assessments from an owner after the effective date of this law, September 14th. When we contact the owner regarding the debt, we have to make reasonable efforts, or the association has to make reasonable efforts to communicate with the owner and offer a reasonable payment plan prior to foreclosing. So what we're suggesting to our boards is that first form letter that you should have some language giving them an opportunity to settle the debt, and so that you are complying with this law. And that can be done in a first letter, a second letter. It can be done by the attorney when it's turned over to the attorney. But we have to give them some sort of reasonable payment plan or offer of a reasonable payment plan before we would ever foreclose on them. And again, this is just going to be something that we do that's form work that will be added to the letters for the collection letters that are sent to owners who pay assessments. The other part of the law is kind of the more complicated law in terms of what can we lien for when an owner owes unpaid assessments. Now, previously, we used to be able to lien for unpaid assessments, late fees, attorney's fees on the unpaid assessments, and any collection costs. The law has changed a little bit now, and basically what it says is that no matter what your documents state, no matter what's in your CC&Rs, Fees and charges like self-help fees or charges charged for an owner's damage to a common area, late fees and fines and penalties can be collected under the common expense lien only by a civil lawsuit. So these charges are going to be collected in the same way as the unpaid fines were collected. So you have to file a lawsuit to collect those, other fees like self-help fees or damage to a common area. So we can't just go ahead and lien for those, even if your documents state that. You'd have to get a judgment and then you can record the judgment. Another thing that this law talks about is that late fees that are not expressly authorized by the association's declaration are no longer part of the common expense lien. And so we have to do a little bit of due diligence before we lien. We want to make sure that if there are late fees that are on the account, before we would lien the property for those late fees, in addition to the assessments, we want to make sure that the association's documents authorize to charge those late fees. Prejudgment interest, we can no longer put on the association's common expense lien. Of course, just like fines and penalties, we can still, get a personal judgment for those. Prejudgment interest fees that you may have. And most of our clients, just don't really charge interest on unpaid assessments. Most of them just charge the late fee. The kind of sticking point on this law, which is going to probably affect how you handle your collections and how you utilize your attorney for your collections, is that attorney's fees and costs now need to be awarded by the court before they can be included in the common expense assessment lien. Previously, we were able to add attorney's fees to a lien without having a court judgment authorizing those attorney's fees. Now we can't do that. Now we have to take the step of getting a personal judgment to collect on those fees. So that's going to be a change. And all the attorneys that practice in this area, it's not the end of the world. Basically, how we're looking at it is if we file a foreclosure against an owner, there will be some parts of the foreclosure that are secured by the assessment lien, and then there will be some parts of the foreclosure that are secured by the ability to obtain a personal judgment against the association. So we'll still be able to collect all of these. It's just the lienable amounts, the amount that we can foreclose on, is going to be more limited to what exactly, is authorized by the law, which right now is basically just going to be the unpaid assessments and late fees if you have those authorized in your documents. So that's just a little bit of a change. That's going to take some getting used to, but I feel confident that we're still going to be able to collect the attorney's fees via the personal judgment, and it's not going to be that big of a change in how we handle things. Collections. An association cannot sell an owner's debt to a third party. I don't really see that coming into play very often. Like, we're not selling debts to collection agencies, but we can't do that. And then also how we apply payments that owners make. So like, let's say they make a partial payment on amounts that are owed to the association. We need to apply those payments made by the owners if they don't have any direction how they're to be applied, like it's not sent in with a coupon or it doesn't say in the notation on the check how it should be applied. In those cases, we have specific evidence now as to how we should apply those. So there'll be some additional things that management companies will need to do when an owner who's delinquent makes a payment to make sure that it's applied properly. Okay, so that's kind of the complicated one. We got that one. So we've kind of covered the transfer fees. We've covered condo improvements. We covered some changes on what we can lien for assessments. Now we're just going to switch to kind of the really easy ones. So we have to have an agenda now for every board meeting. And this applies to planned communities and condominiums. And we have to provide that agenda. Previously, we had to give it to the owners if they came to the meeting, right? That was the old law. But in addition to that, now we also have the secretary of the association or the management company, whoever provides the notice of each meeting. They're also going to have to provide an agenda at the time that you send out your notice of the meeting. And that needs to be provided to the owners by hand delivery, mail, website posting, email, or any other electronic means, or posting it at the association's documents. So, when the new law went into effect a couple of years ago, stating that we had to give the agenda to owners if they attended the meeting, our firm was telling all of our clients, it's just good business practices to, when you send out the notice of the meeting, have the agenda there too. Now that's the law. So starting in September, you will need to make sure that your notice of your regular board meetings also includes an agenda for that meeting. Okay, another new part of the law talks about declarant control, and this applies only to planned communities and gives us some direction about, when the declarant control period ends and other things pertaining to declarant control. Because it doesn't really apply to most of our associations are not still under declarant control. Just be aware if you're a planned community and you're having trouble getting your developer to turn over the association to its owners, there is a new law that talks specifically about the process to do that. Okay, mounted flagpole holders is another new law. We always have laws on flags almost every year. I think over the past decade, we've seen, some sort of regulation of the flags and flagpole laws. This year was no exception. Associations under the new legislation may limit members to 2 wall-mounted flagpole holders. So legislature picked up on it and decided we need to limit that to 2. The next law talks about fair housing violations and CC&Rs. And so really the bottom line on this is if your association's CC&Rs contain outdated language that could be considered a violation of the Fair Housing Act. So, for example, maybe it discriminates against a certain protected class, or it just in general doesn't comply with the Fair Housing Act, which, prohibits discrimination of protected classes. The association can amend that out without getting a vote of the membership. So just be aware that if your documents contain any really outdated language that is discriminatory and in violation of the Fair Housing Act, there's a process for you to get that language out without having to do a vote of the membership. 2 questions that we've kind of been receiving a lot of feedback on, and it's not something that I think is going to come up very often, but are casitas and chicken coops. So I'm just going to spend a little bit of time talking about those 2. So there was a law this year that talked about casitas and dwelling units that might be situated in the backyard of a house. There's been a lot of publicity on this as well that, there's a law this year that talks about this. So you might be thinking as an association, oh, somebody's going to want to put in a guest house, or they're going to want to put in a house in the back of their lot and bring in renters or whatever. Basically, what this law does is it doesn't supersede any of the governing documents that put restrictions or limitations on ADUs, alternate dwelling uses, or casitas. So you can still have any restrictions that you have in your documents will still apply. So if you don't allow any sort of a accessory dwelling unit or a casita or a guest house, that is still enforceable, even with this new law that talks about, the ability for people to do this. We just have to rely now on document enforcement mechanisms and not on what the city code or ordinances may say on ADUs or casitas or guest houses. So as long as it's in your CC&Rs that they can be regulated, you can still regulate them. Okay, let's talk about chicken coops. This has kind of been a hot topic over the years. So we've seen many different cities, municipalities talk about this. It's actually a very heated discussion topic. Whenever we talk about this, there's always some people very in favor of it and then some people very opposed to it. So our legislature has finally spoken, our Arizona legislature, and basically it says that municipalities cannot have stricter prohibitions on backyard chickens than specified in this particular new law. And municipalities cannot prohibit owners of a single-family detached dwelling from maintaining up to 6 chickens. Chickens must be enclosed. Setback requirements must be met as well. If the lot is less than 1 acre in size, the chicken enclosure cannot be higher than the fence line. Roosters are still prohibited. Chicken enclosures must be cleaned twice a week. We don't know how that's going to be enforced, but that's what the state law now says. This really doesn't impact any association restrictions on chickens. A lot of associations already have a prohibition on, it typically says fowl, people having fowl or chickens or whatever, undomesticated animals on their lots. Those provisions in your CC&Rs would still be enforceable under the CC&Rs. If you're having a problem on this, or you think this could be a problem in your association, now would be a good time to check your CC&Rs and see if you have anything in there on, undomesticated animals or prohibitions, poultry, fowl, chickens, etc. So that if you have somebody that does do this, you are already thought ahead about it and what your association's position is on it. And of course, if this becomes a problem, you might want to do just a reminder to your neighbors or talk about it at your annual meeting as to what the association's documents state on this particular topic. Okay, so we covered a lot of territory on the new legislation. Just to recap, we talked about the transfer fees. We talked about condo improvements that may disturb other owners and the new law on that. We talked about how we're going to be changing how we do some of our assessment collection. We talked about putting that agenda out to everybody with the meeting notice for planned communities and condominiums 48 hours in advance of your meeting. We talked about there's a provision in the new law that talks about when declarant must give up their control of the association and some other important information regarding developer control boards. We talked about the flagpole holders, limiting it to 2. We talked about the ability to amend CC&Rs to get rid of fair housing violations just by a vote of the board. We definitely want to talk to your legal counsel before you do that. And last but not least, we've talked about ADUs, casitas, and chicken coops this year. So what I tried to do is just make it as easy to understand as possible. Hopefully, I was able to do that this morning in the quick little 20-minute summary that I gave. As always, we will be talking more and more about this as we get closer to September 14th. So stay tuned. We're going to be putting out a very simple cheat sheet for everybody to understand that clearly explains these laws without a lot of legalese. As you can imagine, it takes a little while to fine tune that. So we're going to be getting that out hopefully before our next Neighborhood Services Virtual HOA Academy, so we can take a look at it then. Okay, let's go back up to our poll results. Looks like we have a great turnout today. We have 11% from Chandler that's here today. We have 4% from Glendale, 3% from Goodyear, 25% from Mesa. Wow, that's incredible. 6% from Peoria, 22% from Phoenix, 20% from Scottsdale, 7% from Surprise, and 2% from Tempe. In terms of our total numbers here today, right now I'm seeing that on Zoom we have about 191 people live with us, which is amazing. Thank you so much for being here, plus many more joining us on Facebook Live this morning. Of those of you who are here today, we have 68% are board members, 13% are managers, and 17% interested homeowners, with 2% other. So a great representation of board members, managers, and interested homeowners today. So welcome, everybody. Thank you for being here. Okay, let's dive right in and talk a little bit about one more topic I want to talk about briefly before we get into our main topic for today. The Corporate Transparency Act. This is something that I'm getting a lot of questions on. So we've talked about this before, for the past really 6 months. And basically, associations, as of right now, need to still comply with the Corporate Transparency Act. Basically, this is a federal law that was passed to, counter terrorism in our country. I don't think under any universe that it was, directed to HOAs and condominiums throughout the United States, but based on the way it's worded, we do have to comply with it. So there's a simple form that associations have to file with information about their board members, contact information for their board members, and that does need to be done by December 31st, 2024. A couple things have happened recently. So, a federal court ruled on March 1st that this Corporate Transparency Act was unconstitutional. Now, the federal government has appealed that decision shortly after the ruling, and FinCEN, which is the Financial Crimes Enforcement Network, has provided notice that, even though this case, was ruled unconstitutional and it's being appealed, the result of that case only applies to the plaintiffs in that case, which kind of doesn't make sense to me, because if one court says it's unconstitutional, that's problematic. But that is the Financial Crimes Enforcement Network, FINSA, who's kind of regulating all the paperwork for this law. So also a couple things have come up, is that the National Small Business Association and members of the Small Business Association, are continuing to fight this. The Community Associations Institute, also has filed an amicus brief, which is like a friend of the court brief in the United States Court of Appeals, on behalf of the National Small Business United and Small Business Association, objecting to, the government's requiring us to comply with the Corporate Transparency Act. So we got to stay tuned. But as of right now, we're kind of at the 6-month mark. We do need to do some planning to make sure that, you are complying with this. Again, this is a really easy form. Our firm will be helping associations get these forms filed. Kind of the biggest pickle on this law is that anytime the board changes or anytime the contact information for the board changes, we have to update our records with this FinCEN, the federal government. And so, it's going to be challenging because we all know people move, people quit the board, new people join the board throughout the year. So it's going to be something that's kind of living and breathing, and we'll always have to be updating it anytime there's a change. So, something you probably need to have on your radar for the second half of this year. We probably should be thinking about filing this form in the fourth quarter of 2024 to comply with the due date, which I would have this filed before December 31st, 2024 for sure. If you are upset about this law and you're not happy about it, a couple things that we can share with you. We have a link, which is from a CAI community associations put this link out. So if you want to get your voters' voice out there and object to this new law, there's an Action Center link that we're going to be sharing with you on our screen. You're welcome to contact me by email to ask for it. And, you can, as a homeowner in your association, you can say, hey, I think it's crazy that we're being required to comply with this law and it's going to cost us a lot of money, et cetera. So we want to give you the opportunity. If you want to file something on that, you certainly have the resources to do that. And it's circulating out there and it's being sent to Congress that we're upset about it. Okay, let's talk a little bit about amending CC&Rs. So great to see 190 people here today in the dead of summer, right? Usually this is not that high of a participation class because a lot of people are traveling, but I'm psyched that we have so many people here today who care about their associations and who want to learn more about what they can do over the summer to get ahead. And so the first thing I want to talk about is amending CC&Rs. We find that during the busy times of the year for associations, and that's typically, we find somewhere between October through May is kind of like prime time busy for associations in our experience. And maybe it's because we've got snowbirds coming, and maybe it's because, kids are back in school typically during that time period. Regardless, those are your really busy times. So the months of July, August, and September are great times to be working on possibly thinking about amending your CC&Rs and also to work on your 2025 budget, so your budget for next year. So let's start with amending CC&Rs. Let's kind of talk a little bit about that. What's the process? Why do we do it? So the most common reasons for amending your CC&Rs would be to get rid of old restrictions, outdated restrictions that no longer apply to your association. Also to comply with new laws. Maybe there's changes in state law or federal law and your documents conflict with that and it's confusing to your owners, so you want to update that. You also another reason for amending CC&Rs is to get rid of provisions in there that aren't consistent with how you currently operate your association. The most common one I can think of is parking. We get a lot of questions on, hey, we've got this parking restriction that we can't park on the streets in our association, but we don't enforce it. Everybody does it. What should we do about it? And in fact, there's a new law that was passed last year that talks about if you're a planned community and the streets are dedicated to the public, you have to take action on whether or not you want to keep being able to regulate parking on your streets. And so, a very common thing that we look at is, okay, things are operating one way in our association and our documents say something different. So we need to correct our documents to make them consistent with what our common practices are. Lots of times we remove developer language. Because the developer is long gone and it's confusing to owners to have all that language in there. Sometimes we amend CC&Rs to make it easier for owners to understand. Use subheadings, shorten them up, condense them so it's something that owners feel is a document that they understand and can read quickly. We also sometimes are correcting conflicting provisions in the documents. If the bylaws say one thing and the CC&Rs say something totally opposite, it's very confusing to members. And so we, amend it to make it all the documents consistent in what they say. What we've done over the years is we've come up with a 5-step plan that is really helpful to associations if you're thinking about amending their CC&Rs. And I've been practicing law for 25 years, representing association, 25 years plus. And what we found is this 5-step plan is a success strategy that will save you a lot of time, effort, and anguish. If you follow this, this will make you much more likely to be successful as part of your amending documents strategy. So I want to share that with you. It's kind of like our secret sauce for, okay, if you're thinking about amending your association documents, what things should you do to ensure that you're successful and it passes? Because I'm going to just tell you this up front, amending CC&Rs is difficult, right? In most cases, you're going to have to get approval of your membership. And, people don't like change. And so what we want to do is package it in such a way to the owners that they can't say no, right? And that's the goal of this. So let's talk about our 5-step plan. Step 1 is a really easy step. Basically, in step 1, we just determine what is required to amend the documents. So we look at whatever document we're trying to amend, like, for example, the CC&Rs. Typically, the amendment provision is in the back of the document. And we look at, what percentage is it to amend the documents? How many owners do we need to actually get this document amended? And so step 1 would be, get your attorney involved for your association. Look at, okay, what exactly percentage do we need? And is there some association documents have like this weird language in there that says that you can only amend 90 days before any renewal. So we have to, evaluate that. Does that apply here? Usually it does, and it makes it more difficult. Some association documents have a weird requirement that you have to have any homeowner approval signatures for the amendment be notarized. And so at this point, basically what we're trying to do is determine what exactly do we need in terms of who needs to approve it. When can we do this amendment? Maybe there's a weird provision in there that says that all first mortgages have to approve the amendment. So we have a strategy for how to handle that as well. So step 1, get your attorney involved, figure out what exactly you need to amend the CC&Rs. And it's good to get this out of the way first, because if it's really difficult, like let's say you have a 90% approval and you have to have all the documents notarized or something, that's going to be hard. And so getting feedback from your attorney as to, okay, how do we tackle that? Maybe we tackle that by amending the amendment provision, because it's so uncontroversial. It probably will be easier to get the 90% and get those signatures notarized, right? So step 1, what do we need to amend the documents? Okay, step 2, this is kind of the longer step. And in this step, we review the documents and come up with the changes. And so basically what we do is we take the document that you're trying to amend, like say the CC&Rs, and we put it into a Word document, and we use the track changes function, and we just start making changes to the document. And what I prefer as legal counsel, and I think this saves money for the association, is for me to do the first draft. And why do I say that? Because if the board does the first draft of the changes, I have to go in sometimes and change what they changed. And it's extra work and it costs more to do that. So it's smarter and more cost efficient just to have your attorney do the first draft off of the documents. And what we do is we use the track changes. I read through the document maybe 5, 6, 7 times, continue to make changes each time I review it. It typically takes about a month for our firm to do this. If you need it on an expedited basis, we can do it a little faster, but for the most part, it's 2 weeks to 4 weeks would be what I would say is our sweet spot on getting these reviewed. After we review them and come up with our changes using the track changes feature, we give it to the board. We ask them to take a look at it. We ask the board to make any changes that they may want, anything that they may want to have added, give us feedback on it, and we can write that in, or maybe they give us proposed language. And so in step 2, basically, we're making the changes. I'm looking at it with the legal eagle eye. I'm also incorporating any changes that the board may want to make. And at some point, After maybe one or two drafts, we've got the document right where we want it. I liked what I'm seeing in terms of the changes. The board is happy with what's, we're proposing to change. And so at that point, we're at the end of step 2. Step 3 is the step that all my clients like to skip, but it is the most important step. So I don't want you to ever skip this. Step 3 is when we take the document that both the attorney and the board agree, this is a good document. We like the changes here. Step 3, we take that document and we send it to the homeowners, whether by email or we put it on our webpage or you mail it, and we ask for their input. Tell us what you think about these changes. And the reason why we do that is because we don't want to spend all the money working on these changes and then find out, when we're voting on it that, hey, I don't like this document. And there's a lot of people who don't like this document. If we rush to the vote and skip step 3, we lose valuable feedback from the owners about how they feel about the amendment. So I really strongly encourage all boards to ask the homeowners for feedback. Give them 2 weeks, a month, and say, here's what we're thinking about doing. Please give us your comments, and give them a little comment card. Tell them how they can email the board. Now, in my experience, you're not going to have very many people that comment on it. Maybe 5, 6 people, maybe less. But the feedback that you get from those homeowners is going to be invaluable. They may say, I don't want this provision. And usually if there's 1 or 2 people who are really upset about something, it's usually an indicator that this section is going to be something that could be controversial and could potentially not get the required votes that we need to amend it. So we need to hear that feedback. As legal counsel for the association, I can tell you that typically controversial topics for CC&R amendments are going to be transfer fees, rental restrictions, anything giving the board more power than they already have. People are sometimes going to question that. But it's good to get the feedback from the owners too. Okay, so step 3, we send out the documents to the owners, ask them for their feedback. We get probably a few people give us feedback. Step 4 is we evaluate the feedback with legal counsel and we come up with what our strategy is for the final document that we're going to send out for the vote. So maybe we put something in there that we got a lot of negative feedback on and people, don't want that, right? If that's the case, what I would recommend is either you just get rid of it, delete it entirely from the document, or maybe you separate that out and vote on that separate. So just that issue has its own line on the ballot to vote on. And just doing strategy discussions on the feedback from the owners is going to help good choices to get the votes that you need. And so maybe we rewrite a few sections after hearing the feedback that, hey, we think this is unclear, this needs to be more specific. Step 4 is really the time that we strategize about the feedback we receive from the owners. We come up with the final draft language after getting the feedback from the owners, and we plan out when we're going to send this document out for voting. A really good time to send these documents out, and now moving into step 4, is in conjunction with your annual meeting, because that's typically when we have the highest percentage of people who are participating and voting. But there are other times too that you can, send out amendments to CC&Rs. It's just we want to be strategic. Like you probably don't want to send out an amendment to CC&R ballot, and July 4th, right, around July 4th, and then ask for it back by July 30th, because so many people are traveling in the summertime because it's so hot in Arizona. So if you do that, you may want to give like a longer time period, like through December 31st or something, so that you have enough time to get the requisite percentage that we need. So all of this strategy is occurring in step 4, and we come up with the final amendments. We create the ballot. We create the timeline for the return of the ballot. And then we finally send out the final document. And what I recommend is you send out the document redlined so people can see what's changed. People get anxious if they see a totally new document and they don't know what's been changed. So, be transparent and have all those changes redlined using the track changes. Have the ballot be easy to understand. Have it be clear on the ballot how long they have to vote on this. And as part of step 4, I always tell the board, be strategic. So let's say we're sending out the ballot now and the end date to return it is December 31st. What I would suggest is that on a monthly basis that we look at how many ballots have been returned and we continue to remind the people who haven't voted, hey, we need your vote on this important issue. We send it to them by email and we keep track of where this is going to. Our ultimate goal, December 31st, is to have the votes that we need. So really in July and August, we should probably be getting monthly updates. As we get into the fall, I would be sending multiple emails a month to people who haven't voted in order to try to get them to vote. Also, always have those ballots available at the board meeting in case somebody shows up. We send them the ballots so they don't have to go look for it in their pile on their desk. Anytime you send out the request for them to vote on it, make it easy for them to vote. Another thing that some boards do is that they have like a coffee and donuts at the park or at the pool to encourage people to vote or to answer any questions that people may have. And that's a really successful tool to try to get people more involved. The last step is step 5, and that is you've reached your goal. You received the requisite number of votes or percentage that you needed to amend documents. Once you hit that step for different documents, there's different procedures. So for the CC&Rs, we have 30 days to record the amendment once we get the requisite vote. So we want to be very careful on that timeline, make sure that we don't blow that. The document gets recorded with the Maricopa County Recorder's Office. Whoever the attorney is who wrote the amendments will help you with the final amendment language on the document and will help you get it recorded. If it's a bylaw amendment, typically those are just kept with the association's records and they are not recorded. So basically just getting the final paperwork for that, having the board members sign the bylaws as amended, and then placing that in the association's records. If it's articles of incorporation, we have to file those with the Corporation Commission. Rules are basically just put with the association's records. Anything that's amended and it's passed, make sure that you notify your owners that it's passed and have easy access for them to get the new document that's been passed. A couple thoughts on this would be make sure that if you use a management company or whoever's providing disclosure statements to potential buyers, make sure that they're giving the new amended document to the buyer and that they're not giving the old CC&Rs. You want to make sure that we're giving everybody the most updated information. So after that document's recorded, if it's the CC&Rs, you want to make sure that whoever's handling those disclosure packages to new buyers who are purchasing in your association, that they're getting the updated CC&Rs too. And have them on your website. All the updated versions on your website is always a great idea. Let's talk a little bit about, rental restriction amendments. And, we have also had case law over the past, couple of years that's kind of put a damper on our amendments. And so I think a couple things that I want to just mention about amendments in the amendment process. Okay, rental restriction amendments typically are pretty controversial. Sometimes you have a lot of support, like people see, we don't want VRBOs coming into our association and we don't have any right now and we don't want any in the future. And so maybe, it's pretty easy if you have a small association to get an amendment like that passed, either prohibiting short-term rentals or, putting some sort of a restriction, like we're going to grandfather everybody that currently owns, but anybody who purchases in the future, they will not be able to rent. There are ways to implement rental restrictions, but they're controversial. You definitely need legal advice in terms of how we're going to structure it, what's going to work best for your association. I always ask the question when a client comes to me with a rental restriction possibility to amend their documents is what percentage are currently renting, because they're not going to vote yes on this. And so there's a strategy if you're thinking about implementing a rental restriction amendment. Another factor here is that there was a case that was decided about 2 years ago called the Callaway case. And that case is making it more difficult for associations to do amendments in general. Basically, the amendments have to be reasonable and they would have had to be foreseeable under that particular court case in order for the amendments to be upheld. And so that's an added layer of analysis that we need to do if we're looking at the amendments that you're proposing, like, hey, could this potentially be challenged under the Callaway case? And your legal counsel will help assist you navigate that process. I have not seen, since that case was decided by the Supreme Court of Arizona, I haven't seen any challenges filed by owners against associations for amendments, saying that the amendments were not foreseeable or that they were not reasonable. I think we've done a really good job navigating that case and some of the restrictions that they put in under that case to help our clients still be able to proceed forward with amendments. So just wanted to mention that because there's a lot of discussion about the Cowley case and maybe we can't amend our CC&Rs anymore. That's not our experience, but you just want to be really mindful of how you do it and make sure that whatever you're trying to change, that we have a strategy so that if it's challenged under Cowley, it's defensible. Okay, let's talk a little bit about budget planning, our last topic for this morning. The month of July, August, September, and October are your key budget planning months for the next fiscal year. Now, most associations have a fiscal year-end date that ends December 31st. And so you need to have your 2025 budget. Typically, it should be approved by the association's board either in November or December. If you're lucky, you get it approved in October. And if that's the game plan, hey, we need this approved in the last quarter of 2024, all the prep work needs to occur now. And so I want to talk a little bit about how to plan your budget. And one great thing, we have two really good cheat sheets right now that I'm sure my office is sharing with you, or you can find them on our website. And the first one was on amending CC&Rs. The second one now is on budget, how to create a budget for your association. So basically, what is a budget? Let's just back it up a little bit for some of you who may be newer to your board or the community association industry. A community association budget is like an itemized summary of anticipated income, like assessment income coming in, and expenses for each fiscal year of your association. Most association documents require you to adopt a budget as a board, and budget preparations typically starting right about now. You should be thinking about it in July, August, and September. And we're going to go through the steps that you should be following over the next 3 months. You also should check your governing documents to see if there's any specific requirements for your budget. Like, do you have to get homeowner approval of your budget? Most of you don't. Like 90% of you probably don't. But there are some, in some instances, some condominiums do have to do that. So you want to make sure you're checking the documents. Who prepares the budget? Typically, it's either the management company or maybe you have like a financial committee for your association, and they're the ones that takes the first stab of the budget. It's typically in an Excel spreadsheet. Anybody needs a sample budget, I'm happy to provide you one. All you have to do is email me at bmulcahy@mulcahylawfirm.com, and I'm happy to provide you for free a budget in an Excel format so you can kind of see how it works and how the formulas work in computing the budget. But typically the management company does the first draft of it if you have one. If you don't have a management company, it's going to be a financial committee or the treasurer for your association. Some key points on the budget are going to be, it takes time and planning and analysis of, the past 6 to 12 months, what our expenses have been to project for the future, what we think our expenses will be in 2025. In some cases, we want to go to the steps for preparing the budget now. So the budgeting process begins by reviewing the association documents. We talked about that already. Are there any special requirements for the budget? The next thing is, when do we have to have this budget approved? And I said a few minutes ago, the goal would be October, November, or December at the latest of 2024 to have the budget approved. So how do we prepare the budget? So you want to look at last year's budget. So maybe look at the first half of 2024 and maybe even all of 2023. And look at the numbers. The year-to-date budget shows, or should show, if you're doing it correctly, what the budget amount was and then what the actual amount is that's spent. Now, what we're hearing from a lot of clients is that they are way over budget on water and electricity in 2024. Maybe you were involved in a lawsuit and your legal fees are much higher than what you had budgeted for the legal fees. Look at last year's budget and the records and compare the difference between the year-to-date budget and what you had anticipated and what it actually is. Then think about, what do we have on deck for next year, for 2025? Do we need to paint the buildings? Do we anticipate bringing on a management company if you don't have one? Are we going to be hiring employees that we may need to do a line item for them? Are we seeing a trend in our water bills going up 20%? Or is Did we receive notification from our landscaper or management company that they're raising their fees? Really think about all of those different factors. Like, are there going to be any changes in 2025 that we can anticipate based upon the information that we have? The next step would be ask questions of the vendors. Maybe reach out to any vendors and say, do you anticipate any fee increases, or do you anticipate any charges for our association? Like, maybe your pool company may say, well, I feel like the pool pump, even though, it's supposed to have a life of 10 years, I think it's just sputtering right now. We're doing a lot of mechanical maintenance on it. I'm not sure it's going to make it. So maybe we should factor in another $5,000 into our budget just in case it doesn't make it through this year or whatever. Or there's going to be more repairs until we, eventually have to get the new motor for the pool pump or whatever. Also ask them, are you going to raise your rates? Or do you anticipate anything? Are you, tree trimming? Are we going to be doing more tree trimming this year than we've done in the past, etc.? Look at the association's documents. I already talked about this the third time I'm saying it. It's really important. Make sure you check your documents about budgeting. Is there anything special in there that we have to do? We have to tick a box, get a vote of the members. Or is this just something that the budget can be approved at a regular board meeting by a majority of the board? After you get the information about any changes that you think, any extra expenses you're going to have for your association, and you've analyzed the data for, maybe the past 6 to 12 months prior, then you can start putting in numbers what you think each line item on the budget is going to, what the expense is going to be for each one of those line items based upon the data that you've received. One suggestion that I have that honestly has saved me and my association, I was the treasurer of my association for about 3 years, is we always had a line item for unexpected or miscellaneous expenses. And for my association, I think our budget is about $2.5 million. And just to give you kind of an analysis of the numbers, I think we had about $40,000 in that separate category that was for unexpected or miscellaneous expenses that may come up that are surprises, because anybody who's ever served as a treasurer of an association knows there are always surprises. It's just like when you have your own home. You never expect the water heater to go out, but when it does, you got to pay for it. So same thing, have that extra unexpected or miscellaneous expense line item for your association. And a good way to look at what you think that should be, look at the past 5 years of budgets. How over budget were we? That might be the number. Maybe a good way to do it would be to analyze those 5 years and then come up with the number that you want to put in that line item for 2025. Budget the amount to be placed in each line item. So there's typically line items for like management company costs and landscaping, legal, and then you put in the expenses for each one. And then after you have all of your expenses, then typically what happens is then you kind of backtrack and then you look at, okay, well, we have, let's make this easy, 100 owners. And you look at the total expenses that you have based upon your estimated budget, and then you divide that by the number of homeowners, and that's going to be your annual assessment. You divide that by 12, and then that will be your monthly assessment. And having done the budget many, many times, I think I've served on my board now over 14 years, what I can tell you is you never go with the first draft of the budget, right? You start playing with the numbers a little bit. Maybe you get a little sticker shock when you look at all those expenses that you think are anticipated and how much of an increase that's going to be for your community members to pay each month. And maybe you're looking at factors like, hey, we can only increase the annual assessment rate up to 10% without a vote of membership. So if we go over that, if your documents say that, if we go over that, now we need to get a vote of the members, which I think anybody who's on a board knows that's going to be a tough sell, right? But one thing I want to mention is all these factors need to be, considered in this timeline right now, July, August, September, October. Because if you do need to have a vote, you're going to need to do that in October and November for sure in order to have this be ready to go by January 2025. A couple other thoughts on the budget. Think about, do we need to go to the membership for the increase? Play with the numbers a little bit. Maybe you lower that miscellaneous expense one to get from 40 to 5,000 or whatever. And how does that affect the budget? And if you're doing this in an Excel spreadsheet with formulas in it, it's going to automatically compute those changes. So it's really helpful if you have it set up that way, and most management companies do. Depending on what your documents say about the budget process, most boards are able just to talk about the budget. I recommend doing this. Talk about the budget, at least 1 month. Go through it line item as part of your board meeting, and then maybe the next month vote on it, or maybe you have to do it the same month you talk about it and you vote on it. But as much input to the homeowners that you can give is helpful, because they're looking at, hey, the expenses are going up, and they may not understand why. So if there's a larger increase, there should be a communications plan put in place to notify the owners why. And what we found is most associations need to have somewhere between a 3 and 6% increase just to meet their, inflation expenses. So one thing that concerns me sometimes is I hear from boards, oh, we haven't raised our assessment in 10 years. We've done really good. And I'm thinking that's not good, because all the other things on your line item expenses on your budget have gone up in costs. And you are, shrinking the amount of money that you have for your association by not increasing it to meet your expenses. And what does that usually mean? It usually means deferred maintenance, meaning that you aren't doing things that you should be doing to properly maintain the property because you don't have enough money, because you're not increasing it enough to meet the cost of living expenses. And so these are just some tips as you're navigating the budget. I'm here to support you. If you ever have any questions, feel free to reach out to our firm, and I'm happy to strategize with you about, preparation of the budget and how to get the homeowners buy-in if you have to do a large increase, or maybe even a special assessment to fund, capital improvement projects, etc. A couple things to think about here as we're kind of rounding out the morning. Don't forget, this is a very important time for budget preparation. One cheat sheet that you may want to take a look at is our cheat sheet on reserve studies and funding. Reserves are going to be the long-term planning for your capital improvements in your association. So I recommend that you take a look at the cheat sheet that we have on reserves. I think that's very helpful. And if you have any questions on reading financial statements or how to read the financials of your association just as part of the budget process, we have a great how to read a balance sheet summary that we're going to be sharing with you here too. It's called How to Read an HOA or Condo Association Balance Sheet. And that can be found at www.activerain.com. And my office is also going to be sharing the link with you. Okay, so that's a wrap on today's main presentation. Looks like we have a number of questions here this morning, about 26 so far. So I'm going to move into the questions. Looks like we're good on time. I'm only 2 minutes behind schedule, so that's great. So I'll start with the first question. My question is regarding the new legislation. We are an 80-unit condo complex, and our rules and regulations have had a long-standing requirement regarding any window coverings that can be seen from the exterior of a unit. So draperies, blinds, curtains, or other window coverings in each unit and on all windows or doors must be maintained at all times. The portion of the window covering visible from the outside of the unit must be white. No reflective materials like aluminum foil, etc., can be placed on the exterior of any windows, which is visible from the outside of the unit. So the question is, one of our owners has complained that the HOA cannot regulate window coverings as a result of the new legislation, as they are an interior decoration per the new bill. HOA disagrees, as window coverings can be seen from the outside of the unit and as such would still be subject to this clause. Can you provide your thoughts on this matter? Okay, so this is you're in a condo, and so we're going to go back and look at the law that pertains to condo improvements that could disturb other owners. I just don't think this falls under that at all. So if you want to do an improvement to your unit that could disturb neighbors, we can't prohibit it, is kind of what the gist of that is, but we can make the owner purchase, install, and pay for anything to minimize the disturbance. I'm not seeing the window coverings falling under this. I think you're well within your rights to continue to enforce that provision in your documents. Okay, next question from one of my favorite former board members. Thanks for still being here. When a board of directors discusses things back and forth among themselves on email, is that considered an illegal meeting? So short answer on that would yes, that probably is a violation of the open meeting law. Anytime you have a quorum of the board present discussing association business, it needs to be an open board meeting. Okay, question number 3. In the past, we've limited spending from the reserve account to capital improvement projects, such as infrastructure components listed in our reserve study. A fellow board member wants to know if it's acceptable to pay for legal fees from the reserve account. So I guess the short answer on this would be you really should not be doing this. I know in some circumstances, when the association doesn't have enough money, sometimes they will borrow from the reserve and then pay the reserve back for the amount that they borrow. However, that's not recommended, and you definitely should talk to your CPA if you would ever want to do that. Okay, question 4. Can HOAs conduct an escrow review on homes that are for sale? Not to stop the sale, but to inform current homeowners and future homeowners of violations. So yes, this is probably already happening at your association. So we have a law called the disclosure law. We have a cheat sheet on this topic that's called transfer fees versus disclosure fees that I would recommend you take a look at. You can find that on our website at mulcahylawfirm.com. So short answer is, if you're an association that has 50 or more lots or units, the association should be providing a disclosure statement. As part of that disclosure statement, a lot of information is provided about the association to the buyer. And one of the factors on this is the association's records, are you aware of any violations on the lot? And you would be disclosing it as part of the disclosure statement. So yes, so you should charge for a disclosure fee. Most associations are in fact taking the step of double checking to see if there are any violations by doing a visual inspection. Some are only going by what's in the file, but we recommend, best practices would be have somebody go out and take a look at the property, because it's a great time to catch any violations that might be in existence and notify the buyer of them. Okay, next question. On number 5, I am a board member of a 1,000-unit HOA. What is typical for working with our community manager? Are they the gatekeeper for communication with our vendors? Is it strange for us to talk directly to vendors? So really, it just depends. I have some large master plan communities where I talk directly to the board. Other large master plan communities where the manager is primarily my contact. The bottom line is, you as a board make that policy. You decide what works best for your community, and then your management company and your vendors support you in whatever your decision is. 6, our association's office is only open 3.5 days a week and refers all financial questions to our attorney, who they also have attend every open meeting. Why can't our board or office just give us answers? It is kind of unusual, honestly, that the attorney is handling the financial questions and also attends every board meeting. I mean, that's not something that our firm does. I mean, if we were needed to, of course we would. And over the years, the past 25 years, I can think of, maybe 10 associations where I went to their board meeting, a few times in that year. But if you're having your attorney at every board meeting, that's really expensive, and that's probably unnecessary. Now, if you're going through a tough time, maybe there's a period of time that the attorney comes, but it's not every month. And so that's odd, I would say. And also that they be the gatekeeper for all the questions. I think that's a little bit odd too, but I don't really know what's going on in your community. Maybe there's litigation pending, or, I don't know. So it's hard for me to comment on it, but I can just share with you my experience, which I did. Okay, next question, 7. Do rules and regulations trump the CC&Rs? No. The order of priority of the documents is the plat, then the CC&Rs, then the articles of incorporation, then the bylaws, then the rules. So they definitely do not trump, the rules definitely do not trump the CC&Rs. Okay, next question, number 8. Our HOA has no secretary currently. Is that legal? I mean, it really depends on what your documents state, but it's not ideal. Let's put it like that. Usually the secretary isn't even really doing that much anymore, because the management company kind of handles a lot of the paperwork for the association, creating the minutes and maintaining the records. I'm assuming that your bylaws state that you have to have a secretary, so you probably are not in compliance with your bylaws. What you might want to consider doing, if you can't find somebody to serve as the secretary, Maybe make it an add-on to another officer role. Sometimes you'll see the secretary treasurer is the same person, or the vice president secretary is the same person. But this is something that I probably would fix and try to get somebody to step in, because like I said, nowadays it's really not that big of a rule, because the management company handles a lot of the responsibilities of the secretary. Okay, question number 9. We adopted a CC&R amendment, or CC&Rs, at an annual meeting, but an amended CC&R wasn't written up. Are the CC&Rs enforceable? So it sounds like you voted on potential changes to your CC&Rs, but you never actually wrote them up and reported them. So those would not be enforceable. What I would recommend is you go back and do the paperwork to get the votes, get ballots out there, and whatever your requirements are to amend, and then record the documents once you get the requisite votes. So this is a really good question. Sometimes things come up the day of the meeting or the day before, and that, like under the new law, the agenda needs to be posted starting in September for 48 hours in advance of the meeting. So what do we do if something comes up after we post the agenda? Well, a couple things you could do would be to update the agenda that's posted, right? Or maybe your agenda has some open-ended topics on it, like new business, old business, manager updates or something. You might be able to push it into one of those categories. But it would be best to have the agenda be as specific as possible. I'm not saying that I'm opposed to you talking about things at a meeting that aren't on the agenda, but I'm just saying be careful about that. One thing you have to be really careful about is if you're doing like an amendment to your documents and you add that to your agenda at the meeting. Well, there's a law that says if you're amending your bylaws, and the board's voting on it, or your other documents and the board's voting on it, that the homeowners should have notice of the amendment and be aware that it's happening, and they should be able to come to the meeting to hear more about it before the board votes on it. So if it's a change like that, you really shouldn't be doing that without having the agenda reflecting that. Okay, question 11. Does the new agenda law apply to just monthly board of directors meetings that the membership is invited to attend, or does it include financial committee that meets periodically and is open to the members? So great question. The agenda law specifically says board meetings. This question's kind of come up a couple times. However, best practices would be if you are distributing an agenda for your financial meeting and it's a regularly scheduled meeting, or your architectural committee and it's a regularly scheduled meeting, it's an open meeting under the law. And so as best practices, I would also post an agenda for those committee meetings. Okay, question 12. Can the board move money from one line item to another without a formal meeting and a formal vote by board and notice to residents? This is kind of a general question. I mean, can they move money? I mean, I'm not sure what that means. So at times we do see on the budget that maybe, okay, so you have a certain pot of money that's coming in, right? Your income that's coming in. And maybe I think what you're trying to ask is, okay, let's say we budgeted $30,000 for electric and $10,000 for legal. And the electric is actually really only $15,000, right? And the legal is actually double what we thought it was going to be. Can the money that's coming in the pot of money, can it be, attributed to a different line item? So my answer would be yes. That happens all the time as we progress through the year. I'm hoping that I'm understanding your question. I mean, this obviously should be something that should be discussed by the treasurer each month in an open board meeting. And like for my association, the only things we talk about year-to-date budget are items that are over or under the budgeted amount and why. And that would be a great time to bring up that we're over on this or we're under on this. And so therefore, there's been some realignment of the funds that are income. Next question, number 13. And that's just best practices, of course. There's no law that says they have to do that. Okay, question number 13. Can CC&Rs be amended to prohibit Section 8 housing? My opinion on that would be, okay, so Section 8 housing, just as a refresher, is like the low-income housing that's sponsored by, governmental agency. They supplement, the rent to allow low-income persons to live in a certain property. I would be very opposed to that because I don't think that would withstand a legal challenge. Question 14, what is the difference and why are there different regulations for HOAs and condos? Great question. So there is definitely a difference between HOAs and condominiums. Go to our cheat sheet called What is an Association? And we define basically it's who owns the common area is the short answer. So in a planned community, the association owns the common areas. In a condominium, each owner owns a percentage interest of the common areas. And so we have a great cheat sheet on that. So you can take a look at that. And why are there different laws for HOAs and condos? And that's a good question. I've been following Arizona legislature since 1995 when I started practicing law. And I can just say that the Condo Act was more extensive in terms of its length from the beginning when it started in 1986. And I don't know, there really isn't a rhyme or reason why some laws only apply to condos, not to planned communities. And, and there's really good examples of this, like late fees. So if you are a condo, it just says that the association can charge late fees, but it doesn't give a limitation. If you're a planned community, we can charge late fees, but it can't be more than 10% of the assessment or $15, and we can charge it on the 15th of each month. So I don't know why. I think it's because if you watch how legislation is made, it's sometimes not the prettiest. And so there's all kinds of concessions that are made to get bills passed, et cetera. And over time, I think we've gotten to the point that there are more planned communities and condominiums, and maybe the Planned Communities Act hasn't kept up, frankly, with the length of the Condominium Act. So I don't know if that's the good answer, but that's the messy answer. That's the messy truth. Okay, question number 15. Our small community HOA posted a sign saying all dogs need to be on a leash. After I notified the HOA of my service animals need to complete off-leash tasks. Oh, so they put the sign up after you told them you need a service animal, and you don't always have the service animal on a leash when they're doing tasks for you. This sign led to multiple incidents of harassment from a renter in our community. I'm assuming saying, why is your dog not on a leash? And actions from the HOA president, including contacting animal control against my service animal. My service animal is always under the control of my verbal or hand gesture commands and has not had any incidents showing otherwise. Animal control informed me that all future calls against my service animal would be dismissed and that I did not violate any laws. However, it's been 2 months and the sign is still up. Our CCNRs only state no pets loose on the property, and I have requested for months for the sign to be rewritten to properly reflect CCNRs stating no pets off leash instead of all dogs. Is there an authority that can be cited to hopefully bring a change to the sign and avoid further harassment? Well, I don't know what kind of service animal you have, so that would be helpful for me to understand that better to answer this question. But let's say it's like a sight dog or a hearing dog, or I think those are some good examples. Typically, those are not on a leash, and the association should not force you to put that dog on a leash if the dog needs to be off leash to take your tasks or to do your tasks. Other dogs, like emotional support pets, those typically are on a leash. And so, in my opinion, they probably could require you to have that on a leash unless you could show that there were some special circumstances that you need the emotional support pet to be off leash. In terms of the sign, I guess I wouldn't get too fixated on that. They shouldn't be enforcing it against you if your service animal is the type of animal that shouldn't be on a leash. And you have legal rights under the Fair Housing Act. If they should pursue that, you can go to the Attorney General's office to file a complaint. But the sign, I guess it could be, you could force them to change it to all non-service animals must be on a leash or something like that. It would be nice if everybody could work together on this and just make it a win-win. I do think the board should evaluate the language on this just because they don't want to get sued, have an attorney general complaint against them. The smart thing for them to do would just be to update the sign. But can the AG's office force them to do that? I'm not sure. Maybe, but maybe not too. Because, all dogs other than service animals, you have an exemption under the Fair Housing Act typically to this. So I don't know if they're going to make them reword it. They might not. Okay, question 16. Once an agenda is posted, can it be changed after 48 hours notice is provided? I talked about this a few questions ago. I think it can be, as long as you resend out the new agenda, if you have time. If not, you might be able to push the topic into like president's report or treasurer's report, manager's report. But if it's one of those special circumstances where the owners really do need to have notice under the law, like if you're amending the bylaws, there's a special requirement for that. You should either push that to the next meeting where you can have proper 48 hours notice of the agenda, or send out a revised agenda. If somebody's going to question it, follow it by the book and either change the meeting date or renotice with the new agenda and get 48 hours notice, or push it to the next board meeting. Okay, question 17. What is the law and the best way to deal with new owners' one-time reserve contribution? Can it be done, and what is the suggested amount? So we have a great cheat sheet on this topic called transfer fees versus disclosure fees. Also, you can take a look at Arizona revised statutes. If you're a condo, 33-1260, or if you're a planned community, 33-1806. There's another special law too that applies to this. I think it's 439, 33-439. It's on our cheat sheet. You can take a look at it. It needs to be in your CC&Rs. It has to have very specific language to comply with the state statute on this. Check our cheat sheet out to get the specifics on how to do it, but it needs to be in your CC&Rs. It's not just something you can start charging, and it has to touch and concern the land. It has to be going to the association. There's all kinds of specific language in the law, so make sure you check that out. Question 18, who gets to keep the transfer fee and who gets to keep the disclosure fee? Well, typically the transfer fee is going to go to the association, unless it's in the documents that it goes to a third party, but that's usually not the case. So the transfer fee or capital contribution fee typically will go to the association, unless possibly, there's something in the management company that talks about this going to the management company. The disclosure fee, and I'm not sure that's enforceable. I'd have to look at your documents and see what the contract says, because the statute says that, anytime you have a transfer fee or capital contribution fee, it needs to go to the association. What about the disclosure fee? Usually that's negotiated as part of the management contract, and more likely than not, the management company takes that disclosure fee. Question 19, is an agenda needed for each board meeting or only the annual meeting? So this is the new law. Actually, let's back this up a little bit. You should have an agenda for every board meeting and for your annual meeting. The new law says starting mid-September, you have to send out an agenda 48 hours in advance of the board meeting. Okay, that's not 48 hours in advance of the annual meeting, it's the board meeting. And you have to hand out an agenda by law at every board meeting too, in addition to doing the notice. Best practices would be to have an agenda, sent out with your annual meeting notice, and also to have an agenda at the annual meeting, but it's not required under the law to have that. Question 20, is the new law regarding CC&Rs regulating parking on public streets in effect? I was under the impression it is on hold pending legal action. So if you look at our cheat sheet from 2023, we talk about a law that was passed. It applies to planned communities who have streets that are owned by the city, municipality, or dedicated to the public use. And it talks about the need to have a vote of the membership, in order to maintain the association's ability to regulate on-street parking. So you had a question. Your question is that law on hold pending legal action? It's not on hold. It's still the law. There were some bills introduced this year that could have potentially changed that law, but it did not change the law. And so take a look at our cheat sheet from 2023 and look at the specific requirements. You probably will have to have a vote of the membership to retain the ability to regulate the streets that are dedicated to the city before a date certain in 2020. I think it's 2026. Could be wrong, but it's on the cheat sheet. So it's I believe it's 2026. Next question. Our CC&Rs require a 75% approval from all residents to change. When we can only get 55% who vote in elections, how can we ever change the CC&Rs? I agree, it's going to be difficult. One thing you might want to do is amend the amendment section. try to get the 75% just to amend just that section to lower it to 51% if you're a planned community, or 67%, which is the lowest you can go for a condo. If you follow our 5-step plan and you reach out to me as legal counsel, what I can tell you is we can help you get there. We've helped associations get 90% approval. It's just, you have to be very disciplined, and there is a procedure that you will want to follow when you're trying to collect ballots to get maximum participation. So it's possible. It's not easy, but it's possible. Question number 22. Our CC&Rs are so old and the copies are so bad. They are practically illegible. How can we get them reprinted in a more modern, legible way without having to retype the entire document? Unfortunately, really the only way to do that is to retype it, and make sure if you do that, that you type it exactly the same way that it was, on the illegible copy. If you can't read it, we're pretty skilled at getting documents from the recorder's office and retyping it for you so that every section you can read and is in a nice format for your owners. Reach out to us if you need help with that. Question 23. If you change your CC&Rs, are owners grandfathered into the old CC&Rs? Really, that just depends on how you amend your CC&Rs. Do you grandfather them in the language of the amendment or not? So it's really all this depends on how the amendments are written. Question number 24. Should the board discussion to terminate our property management contract take place at an open meeting or an executive meeting? So good question, kind of a loaded question. So if you're talking about a vendor under the open meeting law, you can talk about their job performance in an executive session meeting. But when you fire them, it needs to be done in an open session. Same thing with hiring someone, open session. So you can talk about job performance in the executive session, but when you go to the firing step, that needs to be done in an open meeting. Number 25, what is a good benchmark for reserve funding? Look at your reserve study for your association. They give you, how much you should have in there. There is no rule of thumb like 3 times your operating expenses should be your reserve. That is not a good rule of thumb at all. You should go with a professional management company who's accredited to help you determine how much money you need in there. Okay, question 26. Looks like we have about 8 more questions. If you just need to make your architectural CC&Rs clearer for the homeowners, do you need to have a vote to make the changes? It really depends. It depends on what the section says about architectural changes. Maybe you could institute architectural guidelines to clarify it, or maybe you will need to do an amendment to your CC&Rs. You probably need to reach out to your attorney to discuss that. Question 27. You've previously answered the question about renters not attending and participating in association meetings without written permission from the owner. Do rules regarding flying flags or posting election signs apply to renters? So yes, the renter has the same, restrictions under the documents and under state law that any owner would have if they're occupying the property. Okay, question 28. Is there a percentage limit to yearly budget increases? You'd really have to check your CC&Rs to see how much, your assessments can be raised without a board of the membership to determine the answer to that question. Question 29. If we have to transfer funds out of the reserve fund back into operating budget to cover deficits, are these transferred funds now taxable? So great question. Ask your CPA that. I'm not a CPA, so I don't know the answer to that, or whoever prepares your taxes. That's a great question for them. Question 30, 4 more questions. Since reaching a 75% yes vote to amend our CC&Rs is very hard, how long can we keep the vote open? I would say for as long as you want. I wouldn't keep it open for more than a year, though. Question number 31. We need a little more understanding of a non-owner attending a board meeting. Okay, great question. So under the open meeting law, any owner is allowed to attend, listen, and participate during a board meeting. If the owner doesn't want to attend, or wants somebody to attend in their place, or wants somebody to attend with them, and they want that person to talk on their behalf, the owner needs to make that person their designated agent in writing and give that piece of paper to the board, or the email to the board saying this person's my designated agent, and then they can attend. So if a non-owner wants to attend a board meeting, either the board allows it and doesn't mind, that's one way to get in. Or the owner makes that person in writing their designated agent, and then they can attend. Okay, question that's 32, last three questions. Our HOA does not have a newsletter or a website and never lets homeowners know when the board meetings are. Only info we get are the dues notice in December and the annual meeting notice. Older owners are pretty much in the dark on everything. So that's usually not a recipe for success. So the more you communicate as a board and the more information you provide and the more transparency that you have, obviously the happier your homeowners are going to be because the information is readily accessible to them. Owners have a right to attend these meetings, so they need to comply with the notice requirements, providing notice of the board meetings and providing in mid-September, providing a copy of the agenda before every board meeting, or they are in violation of the law. Question 33, I hear terminology HOA, planned community, and condominium. Please clarify the distinction. Okay, so HOAs and planned communities also are known as PUDs. That is going to be kind of the slangs for those. That's one category. So a planned community is kind of also known as an HOA and also known as a PUD. And the legal distinction is that the association owns the common areas. If you are a condo, really they only call it condos, typically, or condominium. That's where the owners, each of the owners owns a percentage interest in common areas. Great cheat sheet on this called What is an Association? You may want to take a look at it if you want more information on that. Question number 34. Our HOA is grandfathered on the street parking regulation. We voted, approved, and recorded the document. Do we lose that privilege to regulate streets if we change the CC&Rs? Okay, so I think maybe you're kind of operating under maybe you weren't aware of the changes in the law last year. So basically, prior to last year, there was some question in our industry about can we still regulate on-street parking if we do an amendment to our CC&Rs? The answer came last year in the form of legislation saying if you're a planned community and your streets are dedicated to the public, if you want to keep your ability to regulate street parking, you have to take a vote of the membership. So look at our cheat sheet from 2023 and take a peek at that and look at what that law says. If you want to keep it, you have to take that affirmative action if you're one of those planned communities that falls under that category. Question 35, last two questions. I am new to the HOA board. How can I get the existing board members to be on the same page in regards to dealing with spending on projects? If I had a penny for every time this question with the same, basic general thought process on this is, I would probably be a millionaire now. It's a very common question. Here's the deal. When you get elected to your board, it's hard because, many of the board members have already been there and they already have a path and a pattern and they have the way that they've been operating for a long time. And so how do you get them to be on the same page as you? Well, sometimes it's easy. Sometimes you come into a board and everybody respects your opinion and they agree with you and honky-dory. Other times you maybe are elected and maybe you're considered like somebody that is, critical of the board, or you're considered, somebody who, is a defector or a detractor or whatever, not supportive of the community or not supportive of the prior board. They may be less receptive to hearing your feedback if you're in that situation. And so what I would do is if you're in that situation, be nice, right? Be professional in how you give your feedback. And if you don't agree with how the board is doing something, professionally state that. If you think they're making a really wrong turn, maybe you need to put it in writing. Hey, I disagree with this and here's why. That's really all you can do. It's majority vote rules on a board. And I hate to say this, but another option would be, to go to the Arizona Department of Real Estate if you think the board is doing something improperly, or a lawsuit. I don't want that for you because that's very expensive for everybody and it's not a good situation. So try to work together. One little tidbit I'll tell you is when I was on my board and then I got off my board when I had a decade of, having kids, and I took a 10-year break and now I'm back on my board again since 2016. What I can tell you is when I got back on my board in 2016, I was unhappy about how things were running in our community. And it took a while for the board to warm up to me. But I will say that I was professional. I was polite. I tried to be a good board member. Even though I didn't always agree with how things were being handled, I was professional in how I documented my concerns. And eventually the board changed and then I got a majority. So it's think long game. Things don't change overnight. Rome wasn't built in a day. You just have to be patient and use some of the strategies that I've given you here today and recognize we've all been there. I had maybe a year and a half to almost 2 years where I was banging my head against a concrete wall where I just didn't like the direction our board was taking, but I managed my way through it. And now I think things are going really well. Last question of today. I was told by the board that Arizona state law said the annual raise to the HOA can go up 25% each year. Sounds excessive. So I think what you're asking is how much can the board increase the assessments without a vote of the membership? Now, a couple things you want to look at. What do your documents state? Right? If you're a condominium, that's going to be what's controlling. How can you increase the assessment rate? Do you need a vote of the membership? Can the board do it? What's the percentage? If you're a planned community, you also want to look at what your documents state. And let's say that your documents say nothing about increasing assessments. Well, then there's a state law that says you can't increase it more than 20% of the prior year's assessment without a vote of the membership. And so the 25% each year doesn't, that's not exactly right. What it says is that if your documents are silent on how much the board can raise the assessment, which is very rare, most documents cover this, and you're a planned community, then you flip over to the state law and it says, you can raise up to 20% of the prior year's assessment without a vote of the membership. So that's it for today. We got through a lot. Gosh, 12:38, hour and 38 minutes. We covered 36 questions and, had a great presentation talking about the new legislation, Corporate Transparency Act, amending CC&Rs, and budget preparation for 2025. Our firm's next live virtual First Friday event is going to take place on Friday, August 2nd at 9 a.m. That's your chance to log into Zoom or Facebook Live and ask a question. And I provide a live answer right then and there. Our next virtual HOA Academy, HOA Condo Academy, will be class number 8 in August. And that will take place on the third Tuesday of the month, like it always does, which is Tuesday, August 20th at 11 a.m. And the topic is going to be, what is a community association? Which we had a lot of questions on that today. Like, what's a planned community? What's a condominium? How does this all work together? How does it operate? And secrets of successful associations, which you really want to tune in on, because the goal of serving on your board is to get things done, to accomplish things, to limit conflict, to make improvements to your community. And so we're going to tell you what's the secret sauce to make your association successful. And we have 25 years experience plus. And I can tell you the boards that are successful, what they do. So it's almost like a little board improvement, self-improvements for board seminar. Hope you'll tune in for that next month. Thank you so much for joining us here today. Really appreciate you being here. You can sign up for any of our classes or First Friday or our neighborhood services, HOA Academy, via our website at mulcahylawfirm.com. Lastly, and most importantly, we want your feedback. So if you wouldn't mind, we genuinely and sincerely appreciate it if you'd give our firm a review on Google or on Yelp. We're going to be sharing a link in the chat on how to leave a review. We're always happy to get feedback from our participants and from our clients about how we're doing. If you like these classes, it's really important for us to get feedback so that we can then provide them to the neighborhood services departments. And this is the best way to do it. If you wouldn't mind doing that for us, I would be grateful, so that then we can provide that feedback back to the neighborhood services departments so that they know that these classes are valuable and we should continue them going forward. I look forward to seeing everybody again in August. Take care. Bye.
Don't forget, our free cheat sheets are available for download at mulcahylawfirm.com.
The intent of our Zoom, Facebook Live, First Friday free call-in, videos, and podcast is to provide a forum for board members and community managers to receive answers to HOA and condo legal questions. Please note, the content in these sessions are general in nature and is not intended to and should not be relied upon or construed as legal opinion or legal advice regarding any specific issue or factual circumstance. You should directly consult with an attorney for advice regarding your individual situation.